Today we're going to be jumping into the Karen Read case. Now this case is set for trial March 12th, so it's coming up, but there were some very important motion hearings that occurred this past week which the judge took under advisement, and some very important motion hearings which we're going to explain and give you the analysis on and explain the basis, go through the law so you actually understand. We don't just provide what here, but we give you the why. Why are the arguments being made the way they are, and how should the judge view the arguments in light of the law? So we explain the law, we break it all down, and that's what we do here. Now, another thing, if you are a first-time viewer of this channel because you've been following the Karen Read case and now you've stumbled upon my channel, well, let me just explain to you what I do. What I do here is I provide objective analysis, which means we look at both sides. We provide arguments for both sides. We think outside the box. We put ourselves sometimes in the shoes of the prosecutor, of the state, and sometimes we put ourselves in the shoes of the defense attorney. That's what you need to do if you want to be objective. Now, I know that this case is very emotionally charged. There are some people very strongly on the Karen Read side. There's some people on the state side. And if you only want to hear arguments being made only one-sided, then this channel may not be for you. We provide completely objective trial analysis. So you've been forewarned, and here we go. So there was a motion this past week, and the issue of the motion, we're just going to talk about one of the main motions that were heard this week, which I think is a very important one. The main issue was that the defense wants the phone records of Elizabeth Proctor. And Elizabeth Proctor is the wife of Michael Proctor. Michael Proctor is the trooper who was leading the investigation into this murder and eventually was whispering into the DA's ear to charge Karen Read, right? So they want Elizabeth Proctor's phone records, and not just all of her phone records that she's ever spoken to anybody, but the phone records specifically that she spoke with Jennifer McCabe, Michael Proctor, Brian and Nicole Albert, and did I say, okay, Jennifer McCabe also. So that's really this web of Michael Proctor, Elizabeth Proctor, Brian Albert, Nicole Albert, and Jennifer McCabe. That's what they want to see the communications about. And we're not going to get into the whole factual scenario here, who is who, and exactly, there's a lot of moving parts here. So if you need to get caught up on the case, there's a lot of other channels that already gave you the basic facts of this case. It's just a little convoluted, and we have a lot to discuss in this case, so we're not going to go through all of the facts of this case. I'm just going to assume that you really are caught up on your own, so we can jump really right into the meat of this motion. So the motion, again, is to get the phone records from Elizabeth Proctor and in her communications with these other people that I mentioned. So I'm going to first go through the arguments that the Karen Read's attorney made. I'm going to go through the response to those arguments by the attorney for Elizabeth Proctor. So first, he argued the following. He said, number one, let's remember that this case is between two parties. The Commonwealth of Massachusetts, which is really the state or the prosecutor, however you want to refer to them, and Karen Read, right? Those are the parties that are in the case. There's no other party that's part of the case. And the argument that he made is that we're asking for these phone records, and the Commonwealth is completely fine with us getting those phone records. So what's the issue here? What are we even doing here? And something that you may be asking yourself, if you know a little bit about the legal process, is aren't attorneys allowed to subpoena records on their own? What? You don't have to go in front of a judge. You don't have to file a motion. We all know that. As an attorney, you have a certain power to subpoena certain records. And if those parties are not compliant with your subpoena, you can file motions for show cause, and you can actually get them thrown into jail. So there can be bench warrants. They can be held in contempt. So what's this whole hearing about in the first place? Why is there even a hearing about this? That's what you can be asking also. But we're going to get to that. We're going to answer all these questions. But let's just go beyond that for a minute and say, okay, so now we're in front of the court. And this argument that the defense attorney for Karen Read is making is that there's only two parties here, the Commonwealth and Karen Read, and we both agree that I should be able to get these records. So who cares if Elizabeth Proctor doesn't agree? She's not even a party to the case. And therefore, he argues that she should not have standing. Standing means that you even get to speak. Not anyone who wants can just get up and speak in court. You have to have standing. You have to have a case in controversy. You have to have some sort of interest in this outcome, the outcome of this either litigation or this case. What's Elizabeth Proctor's interest in the outcome of Karen Read's guilt or not? So therefore, they're arguing, the first argument that he makes is that Elizabeth Proctor doesn't even belong here. She can't even open her mouth. She can't even say anything. That's his first argument. And therefore, since the defense, Karen Read, and the Commonwealth agree that we should be able to get these records, case closed, we should be able to get the records, number one. Number two, he argues that the DA said, he sent out a video, the elected DA, not the prosecutors on this case, but the DA, the elected DA sent out a video saying that there is no relationship at all between the Proctors, the Alberts, or the McCabe's. There's absolutely no relationship, and anybody that tells you that there is a relationship is lying. Therefore, the defense attorney argues that we've got pictures. We've got pictures showing that there is some connection between the Proctor family and the Albert family and the McCabe family. We've got pictures just showing that. On top of that, we have a Facebook post by Michael Proctor's mother. Again, Michael Proctor is the trooper who is investigating this case. So we have Michael Proctor's mother posting on Facebook saying that the Albert family, who's related to Jennifer McCabe, is their second family. That's a pretty strong relationship, not just a casual friend, but you're calling them your second family. So that shows that there's a very strong relationship there. And finally, you have September 25th, 2023, there was an instance where Jennifer McCabe actually went over to the Proctor house. She was actually there, and this point is not disputed. The Commonwealth did not dispute this part. Nobody disputed this part. Everybody agrees that Jennifer McCabe was at the Proctor house on September 25th, 2023. Now, was Michael Proctor there? Michael Proctor, if he's the investigating trooper, and he's friends with Jennifer McCabe, and again, one of the arguments here that Karen Read's defense attorney is going to be making is that really Jennifer McCabe is actually involved in the murder, and she should be a suspect, certainly somebody of interest, and she's friends with the investigating officer. Well, what do you think? You think the investigator officer is going to charge her? They're friends. And that's going to make this whole investigation stink. And that's going to be the basis of an eventual motion to dismiss the whole case based on this misconduct or based on this conflict. So that's a third point. So you see that there is a connection between Jennifer McCabe and the Proctors. Now, he also argues that they have a constitutional right to prove bias. Now, if you are friends with somebody, then obviously you're going to be biased in prosecuting them. So since there's a constitutional right, and he quotes a case called Davis versus Alaska, so therefore Karen Read has a constitutional right to be able to prove bias, which would mean that she has to be able to see the phone records to see what types of communications there's been between Jennifer McCabe, Michael Proctor, Elizabeth Proctor, Brian and Nicole Albert, etc. Now, he concludes, this is Karen Read's attorney, he concludes his argument by saying that he thinks that Elizabeth Proctor's defense is that it's violating her privacy rights. By obtaining her phone records, you're violating her privacy rights. And that's true, you are violating her privacy rights, but he says that in light of Ms. Read's due process rights, the due process rights should for sure overwhelm whatever privacy rights Elizabeth Proctor has. So you're right, the way that this defense attorney, that Karen Read's defense attorney is looking at this, is that you're right, we are somewhat violating Elizabeth Proctor's privacy rights, but in light of Ms. Read's due process rights, which are a very, very strong right that we all hold, it should trump any privacy rights. And then he sits down. So what's the response? So the response by Elizabeth Proctor's attorney is that, first of all, what I thought was interesting, which is cute, he calls the other attorney brother. You may have been watching this and you'd be like, well, who's he talking about when he's saying my brother? My brother said this, my brother said that. Well, really what he means to say is brother counsel, which is, of course, the name of our channel. So he means to say brother counsel because that's how you refer to each other in court. But he's just cutting out the counsel part and he's saying my brother, referring to Karen Read's attorney. So that's just, I thought, something interesting to point out. Now, number two, he says that this has nothing to do with privacy. This is Elizabeth Proctor's attorney. He's saying this has nothing to do with privacy and whether that outweighs Ms. Read's due process rights. Nothing to do with that. It all is about the case called Lampron, which we're going to do a dive into just shortly, and we're going to explain everything. You're going to understand everything perfectly after we're done with this. But he says that there's 4 requirements in Lampron, which the defense for Karen Read did not prove. She did not satisfy these 4 requirements that are required under Lampron. And also, there was an affidavit that was attached, that the attorney attached, and he says that this affidavit is filled with conjecture and allegations that are not supported. And in Elizabeth Proctor's attorney, he attached an affidavit which are facts that are laid out based on personal knowledge of people who knew Michael Proctor and his relationship with any of these people, and also specifically that on that date, September 25th, 2023, that Michael Proctor was actually not home. When Jennifer McCabe was there, Michael Proctor wasn't even there. So that's something else that he puts in his affidavit. Also, he says that the relationship was very distant. Also, he says that Colin, I think it was Colin Albert, who was at this wedding that was in part of the pictures. So he was only 10 years old at the time. So that's also just another point to be made. And then also he makes a point that this whole Rule 17, which we're going to get into in a minute, this whole Rule 17 motion is only for admissible evidence and not for discovery. And really, they just want discovery here to be able to be used in an eventual motion, and it's really not going to be admissible evidence. So that's what his argument is. And finally, there was one other attorney who mentioned that Elizabeth and Jennifer they weren't even just talking about the case, they were talking really just about all the harassment that they received because of the publicity of this case and because of all of Karen Read's support. So they're just kind of commiserating with each other about the harassment that they've received on this case. Okay, so those are the arguments made against being able to subpoena these records. Now, do any of these arguments hold weight? So we're going to get back to the arguments in just 1 minute. But first, let's go over this Rule 17. This is all under Massachusetts Rule of Criminal Procedure, Rule number 17. And Rule number 17 is the following. It governs the issuing of a summons or a subpoena to a third party. A third party is a party, what we lawyers call third party, are parties that are not actually part of the case. We call them third parties. So if you want to subpoena third-party records, you want to subpoena records from a party from a person or a facility that has nothing to do with, that's not named in this case. I shouldn't say nothing to do, but it's not named in this case. We call that third party. Now, there's nothing wrong with that, and that happens all the time. So, for example, let's say you have a person who is injured, and you want to see how injured they are, and you want to see some of the medical records. So you can subpoena those medical records from those medical providers. Those medical providers are considered third parties. And still, as an attorney, you certainly have the right, certainly if you have a case going on which you need the medical records, you could subpoena that. When it comes to a criminal case, so there's sometimes certain rules that govern how to obtain those records. And that's what Rule 17 is about. Rule 17 is about obtaining records from a party that's not part of this case. And this is what the rule says. The rule says the following. A summons may also command the person to whom it is directed to produce the books, papers, documents, or other objects designated therein. So that's part of what a summons can do. The court, on motion, meaning if someone files a motion with the court, may quash or modify the summons if compliance would be unreasonable or oppressive. So already we see 2 instances in which the court may quash this summons, which would be only 2 reasons so far. So let's take it slowly. Under the rule, this is Massachusetts Criminal Procedure Rule number 17, the 2 reasons why the court can quash, not allow the production of these documents, is if it's, number 1, unreasonable. So you have to prove that it's unreasonable to ask for these documents. Or number 2, oppressive. If it's just oppressive that you're asking for these documents. You have no business asking for these documents. So those are 2, and again, the burden of these are very high, to prove that it's completely unreasonable or to prove that it's oppressive. So, but those are 2 areas in which the court rule itself, the rule of criminal procedure itself, says specifically that the court can quash it and say, no, we're not allowing you to obtain those records. So obviously, we need more guidance about this rule number 17. So that is where we get to the case of Lampron. This is the case of Lampron. This is what everybody was talking about during, not everyone, but this is what was being mentioned during that hearing on this motion. The case of Lampron. It's called Commonwealth versus Richard Lampron. And in this case, we had a similar situation where there was being requests made of third parties for documents. And this is what the court, the Supreme Judicial Court of Massachusetts, was being asked. This case asks us to define the showing of relevance and clarify the procedure that is required under the rule. So, number one, what relevance does there have to be in order to obtain these records? That's number one. What does it mean relevant? Number two is what's the procedure? What procedure do you have to follow in order to get third-party records in a criminal case? So, they continue. Pursuit of documents and records in the possession of a non-party must be considered and analyzed under Rule 17a(2), which is exactly the rule that we just mentioned. So, this is what they say. Because we have not previously considered the question, it is appropriate to look at the federal analog of Rule 17a(2), on which our rule was modeled for interpretive guidance. So, let's remember, there's two separate systems. There's the federal system and there's the state system. We are right now, Karen Reed is in the state system, which means that you use the state rules of criminal procedure and you use the state court rules. You don't use the federal rules of civil procedure, federal rules of criminal procedure. But very often, the state will model their rules after the federal rules. So you have the federal rules, which really pertain to federal cases, and then you have the state, which sometimes also will model the same exact rule that's brought in the federal system. So you have the federal system over here, the state system over here, and the state system will take a look at the Rule 17 of the federal rules of criminal procedure and say, that looks like a good rule. Let's basically copy and paste. No problem with plagiarism there. So the Supreme Court of Massachusetts is acknowledging that, and they're saying, well, that's what we modeled it after, so we should probably look to the federal rules for guidance on how to interpret our state rules of criminal procedure, specifically in this case, Rule number 17. And this is what they say. Under Federal Rule Criminal Procedure 17, which is essentially going to be the same thing as what they're going to apply here, the party moving to subpoena documents to be produced before trial must establish good cause. They have to establish good cause to get those documents, satisfied by a showing of 4 things. You have to show 4 things in order to get these documents, in order to prove that you have good cause. Number 1, that the documents are evidentiary and relevant. Okay, so they have to be evidentiary documents and relevant. Number 2, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence. So they have to be not otherwise being able to get produced. Number 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. So you cannot prepare effectively for trial if you don't have these documents. That's another requirement. So you have to show that you need these documents to prepare effectively for trial. Number 4, that the application is made in good faith and is not intended as a general fishing expedition in quotation marks. Again, that the application is made in good faith, this is the 4th requirement, and is not intended as a general fishing expedition. Now, a little bit of advice to all of you. If you are ever looking for a lawyer, you're ever looking for a litigator, ask them, have you ever heard of the term fishing expedition? And if they've only heard of that term, and when they're going fishing on Sunday with their friends, then you should not walk but run. Because this is a term that everyone who's in litigation hears all the time. Fishing expedition. And the idea of fishing expedition is the following. When you are in discovery, so discovery is a phase, it's a process during a trial, before a trial. And in the discovery phase, you're trying to figure out what documents say what and what evidence can help you, and things to help you to prepare for trial. It gives you a good idea of what the other side has, what other documents they have, and you can take depositions as part of discovery. Okay. Now, discovery is not limited to only documents that are admitted in trial. You can also obtain documents in the discovery phase that are not technically admissible during a trial, as long as they can reasonably lead to admissible evidence. Okay, so it's much broader than what you can actually admit during trial. So let's understand that. The discovery phase, the discovery process, is that you can obtain any sort of documents that could reasonably lead to admissible evidence. But the documents themselves don't necessarily have to be admissible during trial. So it's very broad. During discovery, you can get all types of documents, even if they're not technically admissible themselves, but if they could reasonably lead to admissible evidence, then you can obtain those documents during the discovery phase. Now, lawyers love taking advantage of anything that they could, right? We all know that. Lawyers try to take advantage of everything. So they'll try to exploit this rule as much as possible. So they're going to try to make very, very broad requests for discovery. They're going to ask for everything under the sun. Everything under the sun and the moon. They just want everything. So that's what lawyers will request. And the way to fight back on that, how are you going to fight back on that? After all, any document that could reasonably lead to admissible evidence is discoverable. So the argument back against that is that this is a fishing expedition. That's what we refer to it in the law. Okay? This is just, you're just asking for everything under the sun and the moon, and it's not reasonable. You're just on a fishing expedition. That's what we call it. You're on a fishing expedition. You're just trying to fish out anything that may, you want us to produce 1,000 papers because maybe one paper will lead you to admissible evidence. That's called a fishing expedition. You're not allowed to do that. That's the fight back on this broad discovery rule. Okay, so let's make that clear. So the fourth requirement, again, is that the application is made in good faith and is not intended as a general fishing expedition. All right, so those are the four prongs, the four requirements under Lampron, which the attorneys are referring to during this hearing. Now, we're going to continue. We're going to explain a little bit more. The opinion continues. Like the Massachusetts rule, Federal Rule of Criminal Procedure 17 is not a discovery tool. So now, Rule 17, we have to understand, is not a discovery tool. So discovery is, like we just said before, discovery is for documents that even are not admissible themselves, but could lead to admissible evidence. That's what discovery is. Rule of Criminal Procedure number 17 in the Federal Rule and in Massachusetts, which are going to apply soon, is just for documents that could be admissible in trial. So it's not as broad as discovery. As general discovery, as regular discovery, you can discover almost a lot of things, even things that are not admissible. But for Rule 17 purposes, and Rule 17 is to obtain records from a third party, that you can only get records that are actually going to be admissible during trial. That is what this case is saying. Now, what is relevance? What's considered relevant? So the case continues. Under our Rule 17a2, as under Rule 17 of the federal rules, the defendant must show that the documentary evidence sought has a rational tendency to prove an issue in the case. It has to have a rational tendency. Is there any rational basis for this document? Can this document rationally prove or disprove an issue in the case? That's what relevance is. And relevance also, again, is a very broad rule, which other rules try to chip away at. But the general rule, which is usually the first rule that you learn in your evidence class in law school, is the issue of relevance. What is considered relevance? Well, relevance is really anything that has a rational basis to prove a certain issue. So if it can prove any sort of issue that's relevant to the case, so then you can bring that document in. So again, it's a very broad rule, but still you have to prove that it is relevant. So let me ask you a question. Are the documents that Karen Reed's attorney is searching for, these Elizabeth Proctor phone records, is that relevant to an issue in the case? What's an issue in the case? An issue in the case is whether she committed this murder or not. Is there any sort of issue that those documents, those potential documents that they can get from her cell phone provider, Can they prove anything specific in the issue of this case? And the answer is, it may not prove her guilt or innocence, but you know what it could prove? It can prove bias. And that is what the argument for the defense, that's what Karen Reid's defense argued. That even though technically it cannot prove her innocence or guilt, but those records, which will show a relationship between Michael Proctor, who's the investigator on this case, and Jennifer McCabe, if it shows some of that, it shows some connection between Elizabeth Proctor and Jennifer McCabe, and it can show some other connections there. So then that would show there's bias. And if there's bias, that affects the whole case. That affects the investigation of the entire case. And that's why they cite that case that shows that there's a constitutional right to be able to prove bias. So that's how they're satisfying, that's how they're arguing, at least the Karen Reid's attorney, that's how he's arguing that it should still be considered relevant under this analysis of Lampron. Now, what's the procedure? What's the procedure for being able to obtain these records? So then the case continues. Although the rule authorizes a clerk to issue a summons for a trial evidentiary hearing, a clerk has no authority to issue such process for attendance or production of documents prior to trial. Only a judge has that authority prior to trial on the filing of a motion. So this answers the question of what is everybody doing here in the first place. If you really want to know if anybody else who's following the Karen Reid knows what they're talking about, ask them, why in the world was there a hearing in the first place on this motion? Why was there a motion even filed? Don't we know that attorneys can serve subpoenas themselves, just get it signed by the court clerk? You don't have to go in front of a judge and have a whole hearing and a whole argument. That should be the question. If they don't know the answer, then you can say, well, here's the answer right here. You can sound smart. The answer is that this case, Lampron, requires that there be a motion in front of a judge, and the judge has to be the one to issue this subpoena or this summons. That's what the case law says straight out in Lampron. So that's the procedure. Continuing. Because a summons for production of documentary evidence and objects prior to trial must be sought by motion, since we just said that it has to be sought by motion, the motion must be supported by an affidavit. So now we understand why there's have to be an affidavit filed. Not every motion, by the way, is supported by an affidavit. A lot of times you have motions that are supported by pictures, by other exhibits. They not necessarily have to be, then it doesn't have to be that an affidavit is attached to every single motion. It just doesn't happen. But in this specific case, the case says specifically that there does need to be an affidavit. So Karen Reid's attorney could not have just attached the Facebook post or attached pictures of Jennifer McCabe's car on September 25th at the Proctor house. He actually had to attach an affidavit itself. That's what the case law requires, and that's why he did it. So now you understand why they're talking about affidavits and why it's such an important role in this motion. Now, okay, but remember that the defense, the attorney for Elizabeth Proctor said, well, his affidavit is just based on conjecture and it's not supported by facts and allegations that are not supported by the facts. So this is what the case law says about how strict do we have to be about this affidavit? Does this affidavit have to be based on personal knowledge, or what are the requirements of this affidavit? So the case law continues. Lampron was very instructive here. So Lampron continues that the affidavit may contain hearsay. So it doesn't have to be based on personal knowledge. The affidavit could be based on hearsay. However, listen to this, however, very important. However, the affidavit must identify the source of the hearsay. So you can't just say, I heard from somebody who's unnamed, who I can't mention to you. I can't disclose my source to you. You can't do that. You have to identify the source of the hearsay. The hearsay must be reliable. And again, hearsay in the first place is not so reliable. So it has to be a certain level of reliable. That's what they're saying. And the affidavit must establish with specificity the relevance of the requested documents. So you have to say what the relevance of the specific documents are, which here is very clear to show bias. And then here we go with the last little bit of a warning here to the attorneys who are going to go, who might take this a little too far and run with it. We are mindful that counsel are bound by an ethical standard of candor to the court, which means don't you just go out there and say somebody said something and you put it in your affidavit and start abusing this rule. You have an ethical duty of candor to the court. So don't stretch this rule now. Fine. So that is essentially the Lampron case as it relates to this specific hearing. And now we understand so much more what's going on with this hearing. Now let's go over some of the arguments, and now everything's going to fall into place so much better. And I guarantee you, if you go now and watch that motion hearing, you watch that entire motion hearing now, everything's going to make so much more sense to you. And you're going to be wanting to just thank me for opening up your eyes to seeing how clear now and how understandable this hearing is. But this is going to be my analysis about the different arguments that were made. So number one, remember the first argument that Karen Reed's attorney made was that Elizabeth Proctor doesn't even belong here. She's not a party, and therefore she lacks standing to even open her mouth, to even argue anything. She doesn't belong here. The Commonwealth agrees with us, and therefore, that's it, Judge. You should just stamp that order. Is that a decent argument or not? And the answer is that it's a very poor argument. Why is it a very poor argument? Because if you take a look at the Massachusetts Rules of Evidence, and you can look it up for yourself, it's 1108. Massachusetts Rule of Evidence 1108. It says specifically in here, I'm going to read it for you. A party moving to summons documents pursuant to Massachusetts Rule Criminal Procedure 17. So exactly this rule. Prior to trial must establish good cause by showing. Okay, it goes through the different things you have to show. And then says, this is B2. At the Lampron hearing, so there has to be a hearing. At the Lampron hearing, the judge shall hear from all parties, so the parties to the case, the record holder, which would be in this case whoever her cell phone provider is, and the third party subject, if present. So if the third party subject, which is here Elizabeth Proctor, decides to hire an attorney, and the attorney wants to speak on her behalf, the judge shall hear from her, or him. In this case, it was a him. So the judge has to listen to it. So this entire argument is just because they missed this rule of evidence. They missed this rule of evidence, 1108, which states clearly that the third party subject does have standing to argue. Okay, so let's just knock that right off the gate. So now let's go to the other arguments that he made. What about the other arguments? Well, you've got this affidavit, as we said, and then you've got these pictures of showing a relationship between the Alberts, the Proctors, and the McCabe's. You have this attorney, you have this meeting on September 25th between Jennifer McCabe and Michael and at the Proctor house. Whether Michael was there or not is disputed, or questionable. But even if it was just meeting with Elizabeth Proctor, well, that certainly can open up the gate, so to speak, to that there is something going on there between the Proctors and the McCabe's. So this could be based on hearsay. That's okay. So remember, no one's disputing that meeting actually happened. So when the attorney from Elizabeth Proctor says that the affidavit is conjecture and allegations that are not supported, well, everybody agrees that meeting occurred between Elizabeth Proctor and Jennifer McCabe. That right away should have raise some flags. So that's not conjecture, and that's not allegations that are not supported. That Facebook post is a post. It's not conjecture, and it's not allegations that are not supported. The pictures, maybe you can argue about who's in the pictures, and if just Colin Proctor was there, so maybe that doesn't show enough that there's a connection there. But there is still some pretty strong facts, even though it may be based on hearsay, but facts that are not just conjecture and allegations. And then his argument that he makes. Again, here's the argument that the defense attorney for Elizabeth Proctor makes, is that, remember, this is only for admissible evidence. It's not a discovery tool. And that's true. as we just clearly read for you in the Lampron decision, this is not, Rule 17 is not a discovery tool. It has to be admissible it has to be relevant, which we discussed, and it has to be actually admissible. Now, are those documents that you get from the phone company, are they going to be admissible during trial? 100%. There is no question about it. They are admissible during trial. You just have to lay the proper foundation, and they are admissible. That's a business record. It's admissible. It's admissible in all these cases. So it's absolutely admissible. Is it relevant? Absolutely. It can show bias. So is it relevant and admissible? Yes. Yet, Elizabeth Proctor, of course, is not going to just agree to that. So therefore, he's arguing that it's not. But if you think about it, you take a step back and think about it, of course, these records are admissible, number one. And number two, they are relevant. They're relevant to show bias, which is a case, Davis versus Alaska, which this is a constitutional right that you can show bias. So yes, those records do satisfy this relevant requirement and this admissible requirement. This is just a broad discovery request which may lead to discoverable evidence. Now, they do argue another point. He argues another point that, well, they just want these records so that they can file a motion to dismiss because of this misconduct and because of the conflict. She's obviously, Michael Proctor's obviously friends. So therefore, that they're not using it as a tool they're not using it to be able to admit the documents. They're using it to be able to file this motion, which is really motion practice, which is really during the discovery phase, and therefore they shouldn't be allowed to get these documents just for the motion. Now, hold on a second. Just let's think about that argument for a minute. If you have evidence which is strong enough to get the case dismissed based on a motion, well, obviously that evidence has to be really strong and evidence that could be admitted during trial. So certainly this is evidence that could be admitted during the trial. If it's so strong and overbearing and shows such a bias and shows such corruption that you can file a motion to dismiss this case based on it, well then there's nothing wrong with doing that. You can't, so this argument really works just the opposite, in my opinion. So what should the judge do in this situation? My belief is that the judge should absolutely allow the discovery of these phone records, and it should be, it fits all the prongs in Lampron that I see. And if the judge doesn't, then I believe it could be a very strong basis for an appeal. If they don't ever get these records, I think it could be a very strong basis for an appeal. So I would imagine the judge would follow my reasoning. If you look through the law on this, you would see, and therefore I think she is going to grant this motion and give them the access to these phone records. All right, well, we'll see exactly what happens coming up. That will be it for today. If you haven't yet, please subscribe, like the video so we can continue bringing this as analysis. That'll be it for today. See you next time.